With me this morning, I'd like to introduce Mr. Carl Eller. Mr. Eller apologizes if he may need to leave a little early because he's got a previous commitment that he may need to attend. So,
well, he's certainly familiar to everyone in this community, and he's welcome here, and as long as he can stay.
Thank you, Your Honors. There is no dispute that the district court set forth the appropriate standard for a motion to dismiss, in that a complaint must contain sufficient factual information, accepted as true, to state a claim for relief that is plausible on its face. But what the court did in making its decision in denying or in dismissing the complaint was to apply a summary judgment standard, in that the court held that the plaintiffs did not state a claim upon which they could prevail, substituting for the motion to dismiss plausibility standard a prevailing standard of proofs at trial. In reaching that decision, or in utilizing a summary judgment test, the court concluded as a matter of law that no reasonable jury could find certain key elements of the plaintiff's claim. Ultimately, the court concluded that as a matter of law, the defendants could not have improperly interfered with any reasonable expectation that plaintiffs possessed a prospective economic advantage of obtaining better benefits for retirees. That involved at least...
I would understand the claim better, I think, if you would tell me why it isn't simply a collateral attack on the mediation process controlled by the district court and Magistrate Judge Boylan.
Because, Your Honor, there are certain, again, key elements with regard to the mediation. The court ordered both...
The big problem is they were excluded from sessions they considered important, and why wasn't that within the control or authority of Judge Boylan?
The tort of interference is one, as the court noted, involves motive and interest, or improper conduct. With regard to motive, what the court, the tort itself requires a finding of intent. Was there a desire to interfere? Whether or not the mediation itself permitted it. And there was significant concern that the mediation was not necessarily controlling the progress of the conversations.
Well, explain to me how the mediation affected the interests of the people that you represent.
There were two classes that went to mediation: the active players and the retirees. The court acknowledged that counsel for the retirees alone spoke for the retirees' interests.
And that the Players Association had no interest in doing anything for you particularly that was contrary to their interests. Is that right?
Not only that, they had no duty. And if you take a look at question 1A in the...
who had no duty?
The players, the active players.
Well, all right. So how can it be interference if they gratuitously did something for your client's benefit?
Well, that's whether or not they did something for our benefit is something that I'd like to address in a moment. But
this is all comparative. I mean, they only got us 900. I forget the numbers, but as I read them, they only got us 900 million when the NFL had inkled they would go to $1.5 billion.
No, Your Honor. If you take a look at the Richardson-Goodell letter, the league had offered the retirees directly a package.
It's an offer. Well, they could still negotiate.
But let's look at...
Is the complaint that your clients weren't allowed in the room with the mediator?
No.
Or is it that the active players didn't allow the retired players to bargain on their own separately with the NFL? It's got to be one of the two, doesn't it?
No. The court emphasized the fact that here, as a matter of fact, the court found...
I'm not asking what the district judge wrote. I read that. Just tell me in practical terms. In real, I'm a lawyer trying to understand someone else's process.
The active players were not a union, so they had no legal right to collectively bargain at that moment in time with regard to anything other than the antitrust violations. The active players were not a union. So they had no duty to bargain on behalf of anyone else. The active players were a class, and as a class, they had no right to compromise the retirees' interests. The Supreme Court has made that clear in the Amchem decision. One class cannot determine or compromise the rights of another class.
Are you arguing that the $900 million that you say sold you short was done to better the Players Association's part of the bargain? In other words, they got more because they sold you short? Is that one of the arguments?
That's one of the arguments, but the most illustrative example is the fact that when the players concluded their agreement as a class, they included provisions compromising the rights of the retirees.
Of your clients to get more, that's your position?
No, our clients got less.
No, I mean, compromise the position of your clients to get more from the league than you got.
Compromise, as the district court noted, to get better benefits than what they had received when they were active players. That's the delta. What rights did they have as of the time they went in, as of the time these negotiations or the mediation was ordered? And what rights did they wind up with at the end? Before they went in, the package that
They being the actives now or the retired?
the retireds,
Yeah, okay, they had a pending lawsuit.
they had a pending lawsuit.
With antitrust claims which were tied to the labor laws, and so it seems to me freestanding were of little negotiating value.
Not really, Your Honor. If you look at practicality, the league itself sent a letter to the retirees telling the retirees that they understood that the retirees were being shortchanged.
What provision in the settlement agreement should I read that will tell me that the retirees' right or privilege to negotiate separately with the NFL in the wake of this settlement was compromised? Give me a provision in the contract that you're relying on.
The legacy provision, that which provided
I thought the agreement read clearly that this was not, this did not foreclose any independent rights of the retirees.
No, it said it didn't release them. It didn't say it didn't compromise them. And it was compromised because you have a settlement by a class. That's what it was at the time the Brady lawsuit was dismissed. You have a settlement by a class of active players which included provisions for the rights or better benefits of retired class.
Well, so your lawsuit that you're here on today is to follow this up and try to get more, notwithstanding of the legacy provision of the other contract. Is that what you're saying?
Yeah.
And it was dismissed, but maybe you're suing the wrong people. You should have sued the NFL or sued them both, or you're saying that the NFL is saying, well, we've given you $900 million and it's been negotiated by the Players Association. This is sort of the confusing part of what you're doing here.
This was a manipulative strategy on the part of the players and the union, which claimed it was not a union at a time that it was acting as if it was a union when the league was saying that it was still really constituted as a union. And the issue came up recently before Judge Doty, where the players went before Judge Doty and were arguing for the right to get discovery with regard to what occurred in the mediation because they wanted to contend that there was bad faith in the mediation, which is exactly where we're at. What happened was provisions were agreed to that would increase the benefits of retirees, correct the position that the retirees were being shortchanged to some extent, but the active players, as a class, negotiated those provisions for the rights of retirees, then incorporated those provisions into a new CBA, and now argue before this court that this court cannot review those decisions because they're now covered by the Labor Management Relations Act because the retiree benefits are now encompassed within the penumbra of a CBA. The complaint originally was lodged appropriately against the league, but what the active players as a class did, then reconstituting themselves as a union, and then as placing those benefits for retirees in the new CBA, compromised those rights that the retiree class was negotiating with the league. And there's no question that they were negotiating. So it wasn't just a mere possibility. It was a probability, because the league was sitting down and actually talking to the retirees about improving the benefits that they would receive above and beyond what they were granted while they were active players. That's interference. Was it tortious? Was it wrongful? Wrongful means were used to achieve that end. They were not a union, and they were not a class representing retirees. And so the issue becomes whether or not that interference, which the court did.
I don't understand the interference. I know the district court assumed it, but I can't see it. I'm looking high and low with a lot of antitrust and labor law background, and I don't see it. I mean, I dare say a strong majority of the labor law professors in the country would say that the union did have at least a right, if not a duty, to resume collective bargaining, decertification or not. They were in a collective bargaining framework. The retirees, unfortunately, not having an employer-employee relationship, didn't have whatever umbrella the labor laws gave them to negotiate. They had their antitrust claims. And they still had them when the settlement agreement ink was dry.
Along with the complaint, Your Honor, we put in affidavits from two leading labor economists who said that what the active players did as a non-union was a violation of the labor laws.
Economists?
Labor academics, I'm sorry. They said what the players did.
I have to discuss it with David Shapiro, my old labor law professor. I dare say that, of course, there's been a lot of disruption of the labor laws in 30 years of NFL collective bargaining, so nothing surprises me in the universe.
But the interference, Your Honor, occurs if you take a look at the joint appendix at 110 through 112.
Something other than an expectation.
No, they were.
And improperly. I mean, yeah.
If it was a mere hope, there would never have been any negotiations. One of the items.
Yes, it was, but it was based. Your client's only leverage was their antitrust case, plus a lot of moral, social, sports, non-legal leverage.
The leverage also, Your Honor,
wasn't taken away from them.
No, the leverage also was what was being negotiated at the time. And as the district court noted, one of the items was head trauma. Years before that head trauma manifested itself in independent litigation, that was a leverage at the time that the league was very concerned about, and that the active players basically submerged by not including it in the new in their settlement agreement, and therefore precluding it being raised.
So the wrong was being locked out of the negotiating sessions, period?
Part one. The second part, if we were merely locked out and no provisions were put into the settlement agreement affecting the retiree rights, then you'd be right. But it was both. It was being locked out and having provisions relating to increased or improved retiree benefits then included in a class settlement agreement for which the class did not represent the retiree interests, and then locking those interests into a new CBA, which are now claimed to be foreclosed from review because they're covered under the Labor Management Relations Act.
You're talking about being locked out of the mediation process. Is that what you're talking about?
Yes.
Okay.
But locked out of the process and then having our very interests determined by someone else.
Yes.
It's both in combination.
And it's your position that that's what happened, and that's when the $900 million legacy provision gets put into the CBA, right?
Yes, and as opposed to, as Judge Slocum said, the active players getting something above and beyond what they otherwise would have had, they got something below and behind what the league was already negotiating with them and what the league had already publicly put out in offer.
This may not have anything to do, but if you're not under the collective bargaining agreement, you're not parties to the collective bargaining agreement. So if there is a dispute over the $900 million legacy, what standing do you have to attempt to pursue a dispute? Does it have to be done by the Players Association who negotiated this collective bargaining agreement, or how will that be done?
That is part of the manipulative strategy. What was done was what the active players thought would result in a virtually invincible barrier to the retirees coming back and seeking relief for the interference.
And that's really the gravamen of your contention of interference with your economic interest.
Yes.
Okay.
Can you give me a labor law case that would suggest that because it was locked, these provisions to your client's partial advantage are now in a collective bargaining agreement, the NFL and the retired players cannot negotiate a separate settlement of the retirees and a trust suit that would provide more benefits as a matter of labor law, which I just heard you argue. But so I need a case for that, because that doesn't sound right to me.
I don't believe so, but if you take a look at the complaint.
You don't believe what? That there is a case?
I don't believe I have a case precisely on point, because it's not an example that has arisen in the past. I mean, unions don't.
I've been doing ERISA cases for retirees claiming more for over 20 years, so this is not virgin territory, but it's in a unique posture.
Yes, and if again in the complaint, and the court noted, when the retirees were negotiating with the league, before the announced agreement with the active players, told the retirees, and this is pled in the complaint, told the retirees that they could no longer continue to negotiate with them on retiree issues because they had reached agreement on those issues with the active players.
Was this before or after the lawsuit was dismissed?
Before. Between the time where the court ordered the mediation and before the lawsuit was dismissed. This was a well thought out strategy, but abusive. As in the Dom versus Planet Solutions case, the court denied a motion to dismiss because they said the plaintiff had the right to present evidence that the defendants acted in bad faith. That's essentially what happened here. There was at least one of the elements that could have happened, that the defendants acted in bad faith with regard to retiree issues by including them both as a non-union and as a non-representative class, fixing those rights and then putting them in an agreement that would forever foreclose the retirees from re-raising those rights with the very entity with which they were negotiating for those rights.
Well, they had an interest because as active players, they're going to be retirees down the road sometime, and so they were paving the way for that eventuality in part, right?
No, because the rights that were fixed only applied to those who had already retired. If you take a look at the legacy fund, it was intended to benefit 2,000 already retired employees only, or retirees only. And
what was their hope based on that they were going to be included? I mean, what in the negotiations, why were they set up, so to speak, that they were going to be participating in this? Is there any evidence in the record to show that?
I'm sorry, Your Honor, evidence in the record to show
that the retired players were going to be a part of this so-called grand settlement, take care of all the problems we got, be done with it forever.
Yes, Your Honor. If you take a look at the Richardson-Goodell letter, which was written way before the settlement of the Brady lawsuit, the league had reached out to the retirees and said, we want to improve, your life. We understand that we've shortchanged you.
It's time for retirees. Anything else in response to Judge Bai? Because that letter is heavily emphasized in the briefs.
Yes. The court emphasized the importance of how the...
No, the answer to the question. What was the hope based on, factually, in an evidentiary manner?
Yeah,
other than the letter?
The letter and the fact that they did enter into separate negotiations, and they were reviewing item by item.
Before the mediation?
Before the mediation, yes.
Okay.
Your Honors, I had requested to reserve certain time for rebuttal.
We'll see.
Thank
I
you.
mean, we understand the case much better now, and it's a long morning.
Okay, thank you.
Mr. Tulamello?
Yes, thank you. Thank you, Your Honor. And may it please the Court. I think on the elements of the one remaining state law claim, there are 4 elements: interference, wrongful conduct without justification, and a non-speculative expectancy. Let me just start with interference. We agree, or we believe, that the district court decision can be affirmed just on that basis. There's no allegation that we released the claims of the retired players. And in fact, the CBA, to which counsel refers, expressly
They're suing you
preserves
for
them.
interference, not because you released anything, aren't they?
That's right, but Your Honor, I don't think...
So you didn't release, but perhaps you did interfere.
I couldn't see how, Your Honor, because nothing that we did compromised or impaired or infringed on their legal rights in any way.
Your papers say that you didn't have any obligation to do anything for the retirees. Is that right? They weren't going to be, they weren't part of the collective bargaining agreement prospective group. Is that right?
That's correct. I think.
With that in mind, through the mediation, how did the $900 million legacy get in the agreement if you weren't representing them and had no obligation to represent them? Explain that to me.
Well, Your Honors, I think as you indicated in your question, that football is a game where next season may be your last season. The active players have an interest and an incentive in providing for and establishing a culture where the active players are providing benefits for retirees, but it's entirely discretionary.
Your adversary just said that the agreement affected only those 2,000 players who are already retired, were not incorporated in the folks whose last game may be today and they may be retired tomorrow. Now, they have an interest, I guess, above and beyond that, don't they?
They do, Your Honor, and if they wanted to pursue additional benefits beyond those that the active players negotiated in the Brady settlement, nothing we did in resolving our claims precluded them from doing so. There were two.
If nothing you did, what about the $900 million legacy? If you sold them short, as they seem to contend, how do you say that nothing you did interfered with? As I understand it, NFL uses their images in films and stuff, promoting the league and tickets and all that sort of thing.
Your Honor, they have all those claims, head trauma, images, whatever those might be. Not a single one of those claims was released. So there could not be interference.
Released, but they're suing you for interference and not releasing the claim. They're saying that what you did has interfered with their right to go to really get what they deserve, as I understand this lawsuit.
How could, Your Honor, the active players, we were locked out of the game, had filed an antitrust lawsuit. We were directed and sent to mediation by the district court. The federal
built a wall for the NFL to hide behind.
Yeah. I don't believe so, Your Honor.
As a practical matter, I think that clearly is what happened.
In my view, that is too.
Even if that were the case, there would have to be some cognizable interference with a legal right. They say, and they agree with us, as the Supreme Court has held for 40 years in the Pittsburgh plate glass case, that the active players or active employees have no duty at all to retirees. As a discretionary matter, they can provide benefits for retirees, but they are not required to. So there's no duty.
That duty, you went ahead and got a $900 million legacy fund which they say was inadequate. And you say we didn't release you to go farther, but you may have interfered with their ability to practically realize anything further, haven't you?
I don't see how that could be the case. If the theory is that we would need to leave our claims open, not resolve the lockout, or not do anything.
Forget your claim. We're talking about their claim, whatever it may be, whatever rights they may be, whether it may be nothing. Maybe if the district court has said, you don't have any leverage at all with the NFL at this point, so you haven't plausibly alleged a lawsuit here.
Your Honor, let's come at it that way. Let's say there's a fixed pie. The NFL has got a certain amount of money. The active players are going for it, and the retirees are going for it. And the question is that somehow interference for the active players to negotiate a settlement of their claim? In Solomon, this court held that allegations that a defendant acted to advance their valid economic interests, even at the expense of plaintiff's interests, is not enough to claim tortious interference. Similarly, this court in a Marinette held under Minnesota law that competitive conduct, which is neither illegal nor independently actionable, does not become actionable because it interferes with another's prospective economic relations. So there's no wrongful conduct here.
I think that's correct. And if you had in your mediation just taken care of the Players Association and done nothing then for the retirees who were a separate class, that'd be well and good. But you didn't do that without any obligation. You apparently negotiated what they say is a pittance when they deserved more than that. And it's my understanding that that's sort of the focus that they have here. Now, maybe I misunderstand it.
Well, Your Honor, I think under the premise of the question, we would be in better position to defend this lawsuit if we had done nothing for the retirees and settled our claim and then entered into a CBA.
No, I think if you had done nothing, then I think the dismissal of the lawsuit would have been proper. When you did something but didn't do it well, as I understand the factors that you started with to begin with, and I looked at those and I read the cases that underlie those, that if you're going to do it, you have to do it right.
Well, Your Honor, I think the question assumes that there's a duty, that we assumed a duty. Counsel to the retirees, if we began to do something, we had a duty to do it right. We did not have any duty at any point to the retirees during the negotiations. Counsel has conceded that repeatedly this morning. And again, that's been the rule under labor law for 40 years.
And you made that clear to the other side here.
There's no question about that. Judge Boylan was intimately involved in all of these mediation sessions, setting the agendas, seeing who the players would be, had a full view of the substantive negotiation terrain, and now we're being told that part of what gives rise to this tort is what occurred in the mediation. I think counsel even used the phrase that mediation was wrongful conduct. So they understood that they had the ability and the authority to handle the claims brought by the retired players. They dismissed those claims without prejudice. That was a litigation decision they made. To the extent that they are claiming, oh gosh, we didn't know, or there was some deception, or this was a smoke-filled room where the retirees' interests were being sold out. In the midst of the mediation sessions, they filed an amended complaint in this case, naming the Brady plaintiffs, Mr. Brady, Mr. Smith, and alleging that they were negotiating retiree issues. They dismissed that claim as well without prejudice. So it is very difficult to see how there could be any interference, let alone wrongful interference, when we were negotiating under the auspices of a federal judicial officer of this court, where we did not release any legal claims that they had, where they dismissed the claims that they had asserted both in the original complaint and the amended complaint, and where there's indisputably no duty since Pittsburgh plate glass 40 years ago, through the district court briefing and through counsel statements today. Finally, even on the last element, expectancy, what valid allegations are there that they had an expectancy of more than $900 million? The sole basis for that claim is a letter that they cite that reflects elements of an offer made by the NFL owners to the union that was rejected by the union. That cannot give rise to a valid, concrete expectation that they would receive those benefits. In collective bargaining, as your honors know, there are multiple proposals back and forth between the union and management. If this tort is recognized on this allegation, management effectively could leak a proposal affecting retiree benefits, and if the ultimate CBA does not hit that level, they can then bring a state court damages suit against the union and its leadership. I think that would be an enormous new weapon in labor law for management. And that's, to your honor's question, can you...
I don't understand that. I mean,
I don't either.
I don't understand how their theory gives management in the future any power.
Let me just back up and try to explain it more clearly.
Before you back up now, as I understand it, they were in the mediation as a result of the suit that they dismissed, correct?
Correct.
They were in the mediation, and then, as I understand your adversary, they were locked out. And if I guess that's a factual determination of some sort, that he says that they were locked out, so they dismissed their case. You proceeded in this locked out, this mediation of which they were locked out, and came up with this agreement. They file a separate suit then against you for within the activities of the locking out of their position didn't get them what they had coming. Now, am I misunderstanding their position, or?
I think that is their position. I think there's not a single case or any authority that remotely would support it. They have to have...
There probably hasn't been many situations like this that have come down the road, so situations bring on new cases with different...
Your Honor, they have to have a concrete expectancy at a minimum for this tort to go forward.
Well, the parallel cases are the breach of duty of fair representation cases, but they can't take advantage of those because they weren't members of either the decertified union or any bargaining unit that the NFL had to recognize.
That's correct. And my point on the...
But the breach of duty cases, insofar as they discuss what representation is wrongful, may shed some light on this.
Your Honor, it would if they were part of the bargaining unit or if they thought that we represented them.
The bargaining was only he had a three-part. The wrong was in three stages, only the first of which was secret settlement sessions that we weren't part of. The second was including us in the settlement agreement, and the third was locking it in the collective bargaining agreement so as to build the wall for the NFL. Now that's starting to sound like some breach of duty wrongful conduct cases.
Your Honor, they have again repeatedly said that there is no duty, and under Pittsburgh plate glass, we have no duty. And coming back to this point,
there's no duty under the labor laws. There's no duty as plaintiffs in a separate lawsuit. There may be a tort duty.
Your Honor, the case is would even be stronger. You'd have two plaintiffs suing the same defendant.
Why isn't there a tort duty? What case would say there's no tort duty when it is universally recognized that the part of collective bargaining is for the current employees to assist, represent, and bargain for retirees? Why isn't that enough to create a duty under tort law?
Well, Pittsburgh plate glass puts that absolutely.
Isn't that a labor law case?
That is.
I'm not talking labor law. I'm saying we're outside that box. We're looking at common law of torts.
Understood. So you have two plaintiffs who are suing the same defendant. two plaintiffs who have Sherman Act claims against the same.
I don't care about the lawsuits, and I don't care about the labor laws. I care about the environment of collective bargaining in the United States, which for a century has included active employees recognizing their own future was in the offing, voluntarily negotiating benefits for retirees, which then most cases deal with whether they're vested or not. Now, the common law has been evolving tort duties for about 200 years, as I recall, looking at it recently. It's a moving target. Why isn't this a perfectly good environment to say common law duty does stretch this far?
Well, Your Honor, you'd be expanding, first of all, the tort beyond
That's
where
what common law judges do.
Second, the only expectancy that they pled here is based on a proposal in collective bargaining that was made to the union that the union rejected. They are now using that proposal that was rejected in collective bargaining outside of the collective bargaining process and trying to predicate a tort suit against the union for not achieving those benefits. If that indeed becomes the law, then anytime a union doesn't achieve benefits for retirees in accordance with a proposal that was made at one point in negotiations will give rise to a damages claim. And bear in mind, this doesn't have to be a suit that's a putative class action. This could be a lawsuit by any retired football player anywhere, suing and saying, I'm entitled to damages.
You're just spreading your labor law umbrella protection a little too far, because in the situation that Judge Loken mentions, we don't have to construe your collective bargaining agreement in any such lawsuit. All we have to do is read it. And I think the cases are that if, unless we have to construe it, we're not necessarily limited by the precedent that you're talking about. And so we may be looking at a whole new ballgame here in this. We disband the union, and then we sue for antitrust, and then we work it all out, and the league says, well, but you got to be a union again. And this is a kind of a particular situation that's not been faced much before.
Your Honor, even if you threw every aspect of labor negotiation about this case out the window, and you had two plaintiffs who were suing a defendant in asbestos, plaintiff one, that's us. We get a settlement because the defendant thinks, hey, you have a good legal claim. There's no duty for us to look over our shoulder to fear a suit by a second plaintiff or a third plaintiff or a fourth plaintiff to say, hey, you guys got too much. That's unfair.
There may not be any duty under labor law, but under a common law tort allegation may be a different story.
I would submit, Your Honor, that would be virtually unprecedented decision to say that there would be a tort duty by a settling plaintiff against one defendant to look over a shoulder to fear a damages claim from a party to whom it owed indisputably and concededly owed no duty. So if you took every element of labor law out of this case and tossed it aside, there would be no tort.
Time's up here, so
But
it's going to be virtually unprecedented whichever way this case is decided by whatever court finally decides it.
Well, Your Honor,
So, that's our job.
And the Supreme Court makes precedent every day, counsel. The Supreme Court makes some new precedent almost every day.
Understand, and I think all that we're asking Your Honors to do is apply the elements of the tort that are set forth in a Marinette and in Solomon. Those cases make clear that as a matter of law, there was no interference and there was no wrongfulness, certainly. Thank you, Your Honors.
Mr. Hausfeld, I'll give you 1 minute, but I think we now have had a very good, it's been thoroughly briefed and well argued, and so I think we know what page we're on.
I much appreciate your graciousness, and unless there are any additional questions, I have nothing further to add.
Good. Well, as I say, it's well briefed, thoroughly argued.
Thank you, Your Honor.
interesting, important. We'll take it under advisement and do our best with it.
Thank you.